Con Law 1, Judicial Review, Just the Rules. Article 3 courts are what courts? Correct, the federal courts, including, that's right, the Supreme Court. The federal courts may hear only cases or controversies. What is a case or controversy? Of course, it is an actual adversarial proceeding where the plaintiff has standing. And the federal courts, the Article 3 courts, may hear cases and controversies based on what? Well, of course, federal question and diversity between two or more states where the United States is a party, and cases involving ambassadors and consuls. Okay, 4 things. Federal courts, the Article 3 courts, may hear, that's right, cases and what? Controversies based on 1. That's right, federal question and diversity. 2, controversies between, that's right, 2 or more states, or where the 3, United States is a party. And 4, cases involving, that's right, ambassadors and consuls. Let's discuss sovereign immunity. Remember, the 11th Amendment, the 10th Amendment is, of course, the principal source of the state's police power. But the 11th Amendment grants the states sovereign immunity from being sued. This means that may a private citizen sue the state directly for money damages? No, a federal court cannot hear a case between a state and a private citizen for money damages. Sovereign immunity. Who does the individual private citizen sue instead? That's right, they can sue officers, agencies, cities, municipalities for money damages. Can a private citizen sue for injunctive relief? Yes, they may not be able to sue a state for money damages, but they can sue a state for injunctive relief. There's one other scenario in which a private citizen may sue a state for money damages, and that is where Congress abrogates state sovereign immunity. In other words, Congress authorizes money damages, giving a private right of action for violations of, that's right, the 13th Amendment, slavery and the badges and incidents of slavery, the 14th Amendment's enforcement clause, and the 15th Amendment, the right to vote on account of race. And we'll discuss right to vote a bit later. Okay, so private citizens can't sue a state for money damages, except they can sue who instead? Municipalities, agencies, officers. They can sue for injunctive relief rather than money damages, or Congress can abrogate state sovereign immunity and grant a private citizen a right of action for violations of the 13th Amendment, which is slavery and the badges and incidents of slavery, the 14th Amendment's enforcement clause, or any other area in which they authorize money damages. So Congress may abrogate state sovereign immunity, and they have in the past. They can sue a state or a state official for an injunction. And how about this? You can't sue a state official or the president or directly, right, for money damages, or the state, but you can sue a state official in their personal capacity. And of course, if the state consents to being sued, which they never do, then you can sue the state. So when can you sue the state as an individual? That's right. For an injunction, when Congress abrogates state sovereign immunity, and or the state consents. Other than that, you can sue whom? Municipalities, agencies, and officers. And of course, you can sue a state official in their personal capacity for money damages. All right, ripeness. What's ripeness? Harm or imminent harm. The plaintiff has to show what? That there's harm or imminent harm, or the case is not ripe. When does this come up on the bar? That's right, pre-enforcement review of a law. Pre-enforcement review, the case is not ripe. The law has not been violated yet. Someone's nervous about enforcing the law. It's not ripe. Next up, mootness. The court ruling would not remedy the problem, or 2, make the plaintiff whole, with our 1 Ruth Bader Ginsburg exception. Wrongs capable of repetition, yet evading review. In other words, they're likely to recur to the plaintiff or to a class of plaintiffs. Also, the defendant could simply cease the challenged conduct, and that would render the case moot. Okay, so the court ruling would not, mootness means the court ruling would not, 1, remedy the problem, or 2, make the plaintiff whole, unless we have a wrong that is capable of repetition, yet evading review. The defendant ceases whatever conduct is being challenged. And there's one other exception, and it does make sense. It's class actions. Class actions are never moot if just 1 member still has standing. Okay, speaking of that, let's discuss standing. There are 3 prongs. You know them. Number 1, an injury in fact. 2, fairly traceable to the defendant. 3, can be redressed by a favorable court decision. 1, that's right, an injury in fact. 2, that's right, it's fairly traceable to the defendant. And 3, it can be redressed via a favorable court decision. Who doesn't have standing? Well, there's no citizenship standing. You cannot sue just based on being a citizen of the United States. What about taxpayers? Do taxpayers have standing to challenge how their tax dollars are used? No. So we have no citizenship standing. We have no taxpayer standing. Taxpayer standing, there are 2 exceptions. Number 1 is to challenge spending based on the Establishment Clause. Congress may not establish a religion. Taxpayers have standing to challenge what? That's right, congressional spending on what clause? That's right, the Establishment Clause. And a taxpayer can challenge collections of their own specific tax assessment, right? That makes sense. But they don't have standing just to challenge how tax dollars are used unless it's based on the Establishment Clause. Next up, third-party standing. A third party in general may not bring an action on behalf of another person unless that third party is hindered from bringing the action on their own. What's a great example? Craig versus Boren. We have a different age in Oklahoma for the sale of 3-2 beer for women and men. Guess who had standing to sue? The owner of the bar, because he had an injury in fact from not being able to sell alcohol to young men, fairly traceable to the defendant, the state of whoever they were suing, and it could be redressed via a favorable court decision. Okay, a very obvious example of third-party standing is that assignees of legal interests do have standing. For example, a collection agency can be assigned claims, and so they can sue on behalf of the creditors they represent. But in general, third party may not bring an action on behalf of another unless that third party would be hindered from bringing the action. As in Craig versus Boren, the bar owner sued, right? Assignees of legal interests have standing to sue, like collection agencies bringing claims against individuals on behalf of creditors they represent. Okay, and there's also that close relationship. If the third party is hindered from bringing the action themselves, someone in an extremely close relationship, like a parent or a spouse, can bring that action. Third party standing, 3 exceptions. Third party is hindered from bringing the action by themselves. The assignees of legal interests have standing, or there is a close relationship such that the third party can and must advocate for the other. Next up, organizational standing. An organization does have standing to sue on behalf of its members if one or more members would have standing on their own, and the claim is related to the organization's purpose. One or more members would have standing, that's right, on their own, and the claim is related to what? That's right, the organization's purpose. Okay, can an organization sue on behalf of its members? Yes, if one or more would have standing on their own, and 2, the claim is related to, that's right, the organization's purpose. How about for an injunction? The remedy is the same for all the members, right? There's no standing to sue individually because each member would have to show damages. So the organization has standing to sue for an injunction on behalf of its members because no damages, the remedy is the same for all the members. And if they want money damages, each member would have to show damages. All right, I realize that was a bit confusing. An organization has standing to sue on behalf of its members if one or more members would have standing, that's right, on their own, and 2, the claim is related to the organization's purpose. What's our remedy in organizational standing? That's right, an injunction. We discussed class action standing. If one person still has standing, the whole class has standing. And of course, the representative, depending on what type of class action it is, the representative must have standing. Okay, Congress can also create standing by passing a law that allows for recovery. But most of the time, we're talking about there is no citizenship standing. There's no taxpayer standing to challenge how tax dollars are used, except to challenge what? That's right, congressional spending based on which clause? That's right, the Establishment Clause. And of course, a taxpayer can challenge their own specific tax assessment. Third party standing. A third party in general may not bring an action on behalf of another unless the third party is hindered from bringing the action themselves. What about the relationship? Close relationship. The third party can advocate for the other, or they are an assignee of what? Some sort of legal interest. Organizational standing. When does an organization have standing to sue on behalf of its members? One or more members would have standing on their own, and the claim is related to what? That's right, the organization's purpose. 2 prongs. Organizations have standing to sue on behalf of their members if one or more members would have standing on their own, and 2, the claim is related to the organization's purpose. For organizational standing, what's our remedy? That's right, an injunction. Okay, class action standing. Well, of course, the rep has to have standing. And if one member still has standing, the class has standing. Okay, that's enough on standing. Let's get into prohibitions. There is, of course, the prohibition on advisory opinions, which is easy to spot. It is asking the court to give advice to another branch of government on the constitutionality of a law. You can spot it. No advisory opinions. The court can't advise another branch of government. That is prohibited. Easy. Another one that's easy is the prohibition on political questions. A political question is something that has no specific injury. And it can't be, it just involves another branch of government. There's no specific injury. It can't be resolved via the judicial process. Okay, when does this most frequently come up? The courts are not going to hear cases based on redistricting, gerrymandering, foreign affairs, the Senate's power to impeach or remove. Those are political questions. Partisan redistricting, unless it's racially based. Foreign affairs, that's Congress and the president. The Senate's power to impeach and remove, those are political questions. They're matters involving another branch of government that can't be resolved via, that's right, the judicial process. There is no what? Injury in fact, no specific injury. It is merely a political question. Another way to think about a political question is that it is a policy determination. Remember, for standing, we have to have that injury in fact. So we can't be looking at something that's just a matter of policy or part of another branch of government. Redistricting, foreign affairs, impeachment, removal. Okay, the abstention doctrine. The federal court may abstain or defer to a state court if there is a potential for conflict over an unsettled question of state law. The abstention doctrine, the federal court may do what? Abstain, or what's the other word here? Defer to a state court. If what? There's the potential for what? Conflict. Over what kind of questions? Unsettled questions of state law. What can the Supreme Court hear? Final judgments from the state's highest court. Generally, Supreme Court may hear, that's right, final judgments from where? The state's highest court. Now, if the state's highest court has refused to hear the case, or there's no right of appeal, then the Supreme Court may hear a case from an intermediate court. Okay, but what's our basic standard here? Final judgments from the state's highest court, unless it's based on, yes, an adequate and independent state ground. The Supreme Court will not hear a case from the state's highest court if that decision can be supported by state law or the state constitution standing alone. What is an adequate and independent state ground? It's something that can be supported by what kind of law? That's right, state law or the state constitution standing by itself, even if a federal question is involved. So adequate, what does that mean? Adequate means it's dispositive. Independent means it doesn't rely on federal law. An adequate and independent state ground, the decision can be supported by state law or the state constitution alone, even if, that's right, a federal question is involved. Adequate equals, that's right, dispositive, and independent means it doesn't rely on federal law. It can be supported by state law or the state constitution alone. And that is judicial review, part 1.